Does she have a strategy? Not maybe. So that's like even if you did I really went back into
Good evening, everyone. Welcome to tonight's Park Township Zoning Board of Appeals special meeting Monday, April 21st, 2025. Call the meeting to order, and we've got our agenda for tonight, and I'm looking for a motion to approve tonight's agenda. Motion to approve. Support. All in favor? Any opposed? All right, motion carries. I've got a lot of feedback. I don't know if everybody else can hear that too. Oh, got it. All right. Next item on the agenda is the approval of the minutes from the March 31st meeting.
Mr. Chair, requested changes to the proposed minutes from the March 31st meeting. I would note that staff provided a revised page 1 to the draft minutes this evening, where clarifies that there was a motion to amend to add an item to the agenda as item 4 at the last meeting. And that the motion was made by myself and not Mr. Cerny. So I would ask that that change be included. Also, that the minutes reflect that the meeting adjourned at 9:55 p.m. And finally, on page 2 of the minutes, second to the last paragraph, states in part the chairperson seeks to ensure that comments are addressing the issues raised by the applicant, so on and so forth. I think that slightly mischaracterizes your comments at the meeting, because it appeared that you were not intending to ensure that anyone made specific comments, but that you were reminding them of the questions posed by the applicant. So I would propose that that paragraph be replaced with The chairperson reminded the audience of the 4 questions posed by the applicant, so the speakers could address those items in their comments if desired.
You also commented that last portion of that agenda should have to do with title or heading for rules for public comment, public hearing. As part of that amendment. We need to add this.
Yes, the changes, there is along with the additional changes I mentioned on page 1, staff did insert a subheading rules for public comment and public hearing, so yes, they would also ask that change be included. Make a motion to approve the draft minutes with those changes.
Support. Yeah, motion is support. All in favor of that?
Aye.
Any opposed? The motion carries. Agenda approved. As amended. Okay. So the next item for us here is the continuation of the appeal. We close the public hearing. After the public hearing, we have our board discussion. So, I guess at this time, this is for us to discuss management and figure out where we're headed here. So, I open it up to for board discussion time. We've got, just as a reminder, obviously, we've got the 4 questions before us. I think it does make some sense. I think the staff comments made some sense and alluded to that maybe being a good sequence of order. I personally feel it's a good one too to talk about item 4 first. I mean, just in my own sense of what I did personally to look at all of this, that's kind of where I started to begin with anyway. So it kind of chronologically made sense to me to start before, go to number 1. And then, I guess 2 and 3 are the other items for interpretation that are being asked by the applicant. So I personally feel like we should start with number 4. That's everybody agrees that makes sense.
Mm-hmm.
So that question 4 was, did the township zoning ordinance in effect from 1963 until 1974 permit the use of STRs in residential zoning districts? I guess actually before we start all of this, do we want to talk about the emails that have since arrived about all of this and how do we? I mean, the time for admitting those, I guess, were probably last week, but.
Yeah, so my understanding is, at least, is that the public hearing, once the public hearing is closed, those are no longer included in the primary record. Maybe Mr. Martin wants to speak to how exactly this meeting relates to that, because obviously the conversation is ongoing. And so I think just as with any meeting, those are recorded just as public comments are with any meeting.
Okay.
And if you wanted to add anything to that, Dan, as far as the comments go.
The public hearing has been closed. You're at the phase now where you are going to be asking questions potentially of the applicant and discussing this amongst yourselves. But the public comment that has been submitted wouldn't be part of the record of any public hearing. It would just be additional public comment sent to the board.
Okay, so in a sense, that would be our agenda item 5 tonight, that would be reported as being applicable to that item, right?
Correct.
Okay. All right, thanks. Okay. Well, I don't, I guess maybe I can begin on that and just walk you through, I don't know, there's a lot of information here, okay, right? And had a lot of time to try to digest this and I had to, with my personal experiences as an architect, you know, I looked at this building or this whole dilemma in front of us as the question of, you know, what is it? What is an STR? How would I go about having something like this in today's world built? You know, you got to go through a process of review, plan review, things like that, right? Have comments back. You know, are you doing the right thing? Is it able to be built in a certain area? So these are all kind of relevant things. This is sort of what went through my mind as I looked through it and asked myself these questions. You know, first, what's the building type? What's its usage? Is there, you know, impact on life safety, health, welfare, all that sort of stuff? But you know, that's sort of the common thing you would do. But you know, things have changed over time, right? That sort of process is probably, it has evolved a lot since the inception of an ordinance in 46 of the local court. So that's where I started. I asked myself a question: what's an STR? In 1946, what is it? And then what is it in 1946? And what is it in 63? Obviously, I couldn't find the definition, right? I know that the township provided a definition of it in 23. But for me to relate it back to this time, that's what I did. I said, what is it? And to me, my answer, I said, since it wasn't defined, what use or structure could an STR be construed to be that allows it to be something that was similarly defined to be and found prior to the 74 ordinance, so to provide the most reasonably fair comparison, while also meeting the purpose to the township's ordinance as defined in Article 1's preamble. That preamble talks about the fundamental purposes of what an ordinance is, and it's to promote health, safety, welfare of the general public, right? So there's not only the building, but there's everybody else. You know, so you got to. This is my opinion and my interpretation of how I read this stuff. But the two are kind of parallel and should be considered as you move forward. And that's what I did for myself. So then I had to ask myself, what is, again, I'm getting there. So what is an STR? What's the definition of it? And I came up with my own interpretation after reading through all these things. You know, I kind of filtered through terminologies. And I thought at the very core, it's, you know, the renting and operation of a secondary or non-homesteaded property, owner's primary dwelling or structure for the compensation and the purposes of serving as a short-term lodging where amenities like water, sewer, and the kitchen are provided and customarily integrated that may or may not mimic the aesthetic and design of a standard family dwelling. So that's kind of the parameter I established for myself as I kind of went through all of this. So like despite the staff report and what it kind of listed as some of the loose terms that were, for the terms that were kind of spelled out for us, I kind of disagree. Well, I don't think that's, well, I ruled out that there was any relation to the 1963 terms, I guess, for, you know, cabin, park, and the dwelling. All those fit the usage of being more transient in nature. Again, they neither explicitly list their usage to be a usage provided for compensation. And I felt like that was something that needed to be part of it, because that's how I feel the usage of an STR. Yeah. And the term hotel, you know, is void because there's no cooking facilities or anything in that definition that may be continued on that tab. So, you know, it's the purpose, to me, it was the purpose and intent of a building type and its usage that's always critical for how it's permitted to be built and where it's permitted to be located. And I believe both, one, that transient usage, and two, that for compensation are the defining elements required for comparing anything associated with the term today that could be known as an STR. That's where I landed. So as such, the most similar potential use group or building type that I can reasonably infer myself, looking at this, to an STR found in the 63 ordinance, are those whose definitions provided similar meaning to a building's purpose to be a transient type in nature and one that's provided for compensation. So therefore, I found one term for that candidate for myself, and that was a tourist home. So that was my chronology to get to where I did, and what I did then is said, well, where's the tourist home located or permitted to be found? And I found that to be permitted in residential district D, commercial and agriculture, based on the matrix I saw. So that's how I got to that for question 4. So I guess to me, a tourist home building type would have been permissible in that residential district B. Therefore, if I'm comparing that, an STR would have been as well. That's how I got to that term. I don't know. But
I came to almost to a similar conclusion through a different path, because for me, it was looking at, I was like, how did we get from there to here? And so I went back and while it's not related, it is something that didn't exist and then became in existence, and that was mold. And how, that had to be revised and, and while it's not relative, it in the sense of, I was, just trying to understand, like, how do you put something into an ordinance that didn't exist or existed a little bit, and then people were like, we don't really think this is a good idea, and, or we need to change the rules, and then how that comes into existence. And so, and then I went back and looked at the transient and trying to understand what that meant, transient versus tourist and all of those terms to make sense of whether it was permitted. And I came to that same conclusion that a tourist home is as close as we can get to a short term. There were a couple things that I saw that I just wondered about too, and there were some things in there, like there are people that own their home and live in them and then go away for a little while, and while they're gone, somebody comes in and rents it for a short term. Well, that's like something we haven't really talked about as a possible way that this is handled. You know what I mean? Like I happen to know people who actually live in their houses. They go away for a couple of months and then they do the summer rental, and then they come back and it is their primary residence. So that kind of mucked up the thought process for me a little bit too, because there's so many different situations.
yeah, mine was a very black and white approach, I feel like, and methodical for, how I'm kind of attuned to making decisions.
Yeah.
That a
But
lot,
it's kind of all
there's so,
different.
it is, and there's so much influence from everything that we've read, seen, heard.
And it's hard when you're reading through the ordinances. Like, I lived in a house that was very clearly someone's cottage at some point. I mean, we had to put insulation in parts of our house that weren't there, that kind of thing. And my house has 7 bedrooms, or one in an office, could be 8. And I was going through here and I'm seeing parking, how much space you're allowed per room and I'm like, oh my goodness, my house wouldn't even meet this requirement because I have a single driveway and I don't have a spot for every room, that's another thing, how does that fit into it? A lot of houses would just be removed from the equation just based on that alone. And they don't have enough parking for the number of rooms they have in their house or whatever.
Correct, and that was a characteristic of something that is inherently in the ordinance to help understand what allows its usage to be functional, practical, allowable, right?
Yeah.
In all these areas that are zoned off, so that there's harmony, right? So anyways. That's. But thanks for sharing that.
Mr. Chairman, I took a very pragmatic approach to this because I was serving on the ZBA when we initially went through a whole exercise to try to determine if there was substantial interest. How would it come about? And so what we started out with was a clear understanding that STRs were not allowed as a proper use in a residential zoning district. But how could we wrestle with it and come up with solutions that might accommodate? We went through, oh my gosh, a year and a half of meetings and having participation from the public. And there were strong arguments both ways. And we listened tentatively. And we finally came to the conclusion, and I think the Board of Trustees did as well, that it was just too complicated and didn't fit the master plan for the township. And so, but I was never under the impression that STRs were allowable use in a residential district.
So obviously, when we're looking at this question number 4, which is, did the township zoning ordinance in effect from 1963 until 1974 permit the use of STR in residential zoning districts? We're looking at the language of the ordinance as it existed at the time. And we're not considering the desirability of the ordinance, the wisdom of the ordinance. We're looking primarily at the language to begin with to see what did the ordinance say. I agree with the comments tonight that the distinction between single family dwelling and a short-term rental, as we know it today, and as it would have existed in the 60s, that the distinctions there are the transient use and the use for compensation. I arrived at that same conclusion as well, and I think that's clearly spelled out in the ordinance leading up to the 1974 amendment. I agree with, based on the definition of a tourist home, that tourist home would encompass what we currently think of as a short-term rental, and that would have been permitted in the Residence B district. I think that definition of tourist home and reading that with the zoning ordinance as a whole and seeing how the zoning ordinance treated transient type uses, cabins, lodging houses, other transient uses, that the township clearly distinguished those from single family dwellings. And so I reached the same conclusion that the township zoning ordinance in effect from 1963 until 1974 did permit the use of what we would refer to today as short-term rental as a tourist home in the Residence B district. You know, if we look at how the definition of tourist home even changed in the 60s, but it states clearly for compensation chiefly on an overnight basis and mainly to transients. And it states that that is excluded from the definition of a single family home. And so that to me is clearly shows the township's intent to call out what is I would refer to now as a short-term rental. And to exclude that from a single family dwelling use. Placing that in the Residence B district as a tourist business or references to tourist homes.
That was more brief than I thought, but I don't know if anybody else got any more comments about that question. But how do we just the conclusion to all of this? How are we answering that question formally right now, or is we need to make the motion?
My recommendation is typically when the planning commission, zoning board of appeals, or township board has sort of contentious issues that you know are likely to go to court one way or another, that you make tentative decisions and direct, for example, maybe staff, the attorney, or Crystal and I to work together to prepare a written report for your review, modification, rejection, or approval at an upcoming meeting. So it's kind of a tentative decision which way you would want that report to come out, but knowing that it's going to be highly scrutinized, you want to give some time, some thought to put it into words that you then review. You could modify it, you could reject it, or you could approve it at a subsequent meeting. That's what we typically have done with planned unit developments, and more back in the day, you used to approve ponds, so we'd often do that with pond approvals with conditions and things. I would recommend that you do something akin to that here tonight.
Specifically, I'm guessing it's because I've been in this school attorney for almost 20 years, but.
That is correct, yes. Yes, just as the chair is an architect, you're an attorney, that would save the township quite a bit of money. It would allow one of the ZBA members to be very involved in it, but it's ultimately subject to your review or approval.
Right, gotcha. Do we do that on an individual question basis, or do we do it at the conclusion of sort of a consensus tonight as a whole?
My personal opinion is that we discuss all of these issues because our discussion could then relate back or change something, and so I think by the end of the meeting, if we have a consensus, we can review that through the recording of the minutes. There's something in writing, but might be premature to.
Yeah, that was hoping that was seen with you. Okay, I feel like if there's no more discussion or question for us, I don't know if there is or if there's more deliberation here from both sides. Okay. I propose we just move on. I'd like to move on to question number 1. Chronologically, that made sense to me as well. And I'll just, that question again, basically, let's see, I'll read it here. Did the 1974 zoning ordinance permit the use of short-term rentals in residential zoning districts? The STRs fall under the definition of single family dwelling. So again, my same process kind of applied here. I don't know what the definition in 74 wasn't defined. You know, I've got my definition that I stated, relating that to whatever potential use group or building type that would be reasonably inferred and listed in the ordinance that would be comparable. I got down to 2 terms. One still the tourist home, still being a candidate for me, and then a motel. Those are the 2 terms I found myself constantly coming back to that made the most sense to categorically compare it to. So that's kind of where I got. So my conclusion based on that comparison was that, you know, tourist homes are permitted in PUDs and the C2 resort district. And then hotels were permitted in the C2 resort service district as well. That was my process.
I agree with that. If we look at the definition of dwelling in the 1974 ordinance in section 3.13, it states that a dwelling is any building or portion thereof which is occupied in whole or in part as a home, residence, or sleeping place, either permanently or temporarily by one or more families, but not including motels, hotels, tourist rooms, or cabins, or mobile homes. Goes on to define single family, 2-family, and multi-family dwellings. But if we look at the definition of a tourist home at section 3.40. That states a building other than a hotel, boarding house, lodging house, or motel where lodging is provided by a resident family in its home for compensation, mainly for transient. So again, there we see the transient use and use for compensation. There was some discussion by the applicant about the requirement that there be a resident family in the home. If we take the resident family out, then I agree that that fits squarely within the definition of a motel as it was defined in 1974 under section 3.27, which states that a motel is a building or group of buildings on the same lot, whether detached or in connected rows, containing sleeping or dwelling units which may or may not be independently accessible from the outside with garage or parking space located on the lot, and designed for or occupied by automobile travelers. The term shall include any building or building groups designated as motor lodges, transient cabins, or by any other title intended to identify them as providing lodging with or without meals or compensation on a transient basis. There was discussion about motel at the last meeting that seemed to focus primarily on the current definition of motel or the definition that was as it was amended in the 2000s. There was some reference to the US Code 17 US Code 119 to talk about to try to draw from that a conclusion as to what it means to be a commercial establishment, which is what we see in a more current definition of a motel. That US Code section, what I can see is taken from the Copyright Act. It addresses licenses for TV satellites. I was not able to find anywhere that that was utilized for zoning purposes under Michigan law. And in fact, even in that code section where it defines commercial establishment, it addresses businesses and establishment with a common business area. That was really the focus of the last meeting, the applicant's comments. But then it goes on to say that it does not include a multi-unit permanent or temporary dwelling where private viewing occurs, such as a hotel, et cetera, et cetera. So I don't think that that is relevant, given what the purpose of that code section is for, copyright issues, not zoning. But regardless, the applicant's focus when it addresses motel is on more recent definitions of motel. Motel definition in 1974, in my opinion, was broader and would include what we would refer to as a short-term rental in today's vernacular. That is even one that is not utilized by a resident family. From that, when you take the resident family out, it falls into the definition of motel. I think we also have to look at when we're looking at the language in the zoning ordinance to determine its meaning. We also look at the C2 district where these transient type uses are allowed. And there's specific reference in the C2 resort district to a reference to tourists and seasonal residents. So obviously at the time, the township did recognize tourists and seasonal residents. And there are very express parking requirements in there for motels and tourist homes. So that again is another indication that those uses, as you indicated, Mr. Chair, were limited to that C2 district. And I would agree that they would also be allowed under the planned unit development section, but not in the residential districts of that. And I think the language of the zoning ordinance itself indicates that with the 1974 amendment, the zoning ordinance became more restrictive, not less restrictive as it pertained to what we would now refer to as a short-term rental.
Another question amongst the group here.
Question one.
That leaves us with, I guess we're gonna move on to questions 2 and 3. And you know, this is something I feel like it's out of our jurisdiction. So I'm curious about what others may think. Opinions about that, or feel like they could answer?
So question number 2 asks, notwithstanding how the ZBA interprets the 1974 zoning ordinance, that the township is stopped from enforcing its amended ordinance, zoning ordinance 2024-01, such that the use of single family dwellings as STRs can continue as a non-conforming use, despite the amendments 2023-02 and 2024-01. I agree with your comments, Mr. Chair, and the staff comments at the last meeting, that this is really estoppel is a judicial doctrine. That's a legal question for a court to answer. I recognize that if the ZBA's decision reflects the comments we've made to this point tonight, there will be people disappointed by that decision, and that decision also is not going to answer all of the questions presented by the applicant, but I think there are reasons we can't answer question 2 and 3, but with regards specifically to 2 and the estoppel question. Estoppel is a question for a court to decide. I also believe that that is a question for a court to decide on a case-by-case basis. That is not a doctrine that has been utilized to invalidate an entire zoning ordinance or to apply township-wide or even to 100 properties. It's just, that's not the intent of that doctrine. If a property owner brings an estoppel claim or defense, that is something the court can determine based on the facts and circumstances as it relates to that specific person or property. Obviously, we have seen and we heard at the last meeting correspondence, comments, allegations of reliance on staff comments, and we understand all of that. And we're not here to dispute that. We're simply not able to render a decision on that, in my opinion. Both because the application states that it is not seeking a decision as to any specific property, and because it's simply outside of the ZBA's jurisdiction to render a decision on estoppel. So I would not be inclined to try to venture a guess as to what a court would decide. That's a decision for another day in a different form.
Is that similar? Yeah, I feel like this, I think we're to stop, stop on the part of the subject there. So,
I think question 3 is related in the sense that question 3 asks, notwithstanding how the ZBA currently interprets the 1974 zoning ordinance, was the 1974 zoning ordinance unconstitutionally vague? Which the applicant describes as being that a layperson was not on fair notice of the conduct prohibited. So was it unconstitutionally vague such that the use of short-term rentals was lawful prior to the 2023 and 2024 amendments, and therefore continuous non-conforming use? This brings up some of the same concerns from my perspective that, number one, this is a question for a court to answer, a constitutional issue. I think this question is outside of the jurisdiction of the ZBA. Also, a non-conforming use, again, is property specific. And so this application does not seek a determination as to any specific property. And with regard to non-conforming uses, that is a fact-sensitive inquiry, property-specific inquiry. As we know, non-conforming uses are subject to local ordinance, state laws that prohibit things like expanding lawful non-conforming uses, discontinuing lawful non-conforming uses. So there are specific facts and circumstances that must be reviewed in reaching a determination as to whether something can continue as a non-conforming use or not. Whether that's the appropriate remedy or an unconstitutionally vague ordinance is not something that I believe is within the jurisdiction of the ZBA to determine. And also whether the ordinance itself is unconstitutionally vague, I also don't believe is within the ZBA's jurisdiction. The circuit court in its decision indicated that the plaintiff's claims did not amount to a facial challenge. In other words, the applicant did not put before the court a claim that the ordinance was unconstitutional on its face, meaning that in order to survive, to prove the unconstitutionality of it, it would be on an as applied basis. And what the court had indicated was that there has not been a determination. There has been no application to a specific property. And so again, we're kind of see this with regard to both issues 2 and 3. These are very broad, kind of overarching issues, legal issues that are outside our jurisdiction and, in my opinion, outside of the scope of this application. I think with regard to unconstitutional vagueness, you know, what we discussed tonight based on the plain language in the zoning ordinance, I think the applicant would have a hard time establishing that something is unconstitutionally vague, even if there was an error made in the past. But again, that's just outside of our purview.
Yes.
I've already provided my legal opinion, which you've discussed in closed session. And unless you guys are really wanting to waive that privilege, you know what my opinion was with respect to your authority and jurisdiction to answer questions 2 and 3.
We can approach.
The ZBA is constrained by the zoning enabling act and the zoning ordinance, and its powers are clearly spelled out. These types of questions 2 and 3, do not fit within the parameters of what the ZBA is charged with or authorized to do. And so, even if we had all of the evidence necessary to render a decision on those 2 items, which I don't believe we do, I still believe that would be outside of the scope of the ZBA. And I would venture a guess that if the ZBA made a determination on those 2 questions and the applicant disagreed, that in a potential appeal, they would argue, court, you don't have to listen to the ZBAs or give the ZBA any deference because they acted outside of their jurisdiction. Sure. A final comment on that as well, with regard to the estoppel, and with regard to non-conforming use. You made a comment at the last meeting that this application is not to determine whether any specific property is or was a non-conforming use at any time, and that had to be determined on a case-by-case basis. By us not answering these questions, it may actually benefit some of the property owners in a sense that it does not foreclose any process that they may attempt to utilize to obtain a decision on that.
So. Sounds like to me, we've been talking for 45 minutes. Feel like we have some sort of a consensus on formulating some sort of response to this, but I feel like that's something, given the nature of what it is, that should be something formulated on the township's attorney's behalf and staff. Really a official response for us to put together and have us reviewed.
Yeah, I think that would be appropriate and consistent with how the township has handled other items in the past to have staff and township legal counsel draft present to us a draft written resolution for us to consider at the next meeting. That's not.
The next meeting is.
I will say it likely will be, but I have jury duty and I have to call like tonight to find out whether I have to report tomorrow. So if I end up on a jury, I don't know if you ever want me on the jury, I wouldn't want me on the jury. Unless I get out, I'm in it. And so my days this week might be filled with showing up and waiting to be called as a potential juror to be dismissed.
Over there, but okay, so, do we need to make a motion to have that even formal approach to handling these questions?
Yeah, my recommendation, which historically what the Township Planning Commission Board and ZBA have done is basically made a motion to direct the township staff and attorney, and if Crystal's willing to work to prepare a resolution report decision to decide in the ways that I understand there's consensus, for example, tonight, which would be subject to your review, modification, rejection, or approval at a subsequent meeting. But you're kind of directing us which way to go. I get the sense that on questions 1 and 4, that the prior ordinance allowed short-term rentals as tourist homes within the R2 district, but under the 1974 ordinance, they were not allowed in any residential district. And that questions 2 and 3, you're taking the perspective that you don't have the authority and jurisdiction to answer those questions.
Residents B, so
Residents B, thank you, sorry.
just so there's no.
Thank you. But yes, my preference would be to have it as a motion so that the ZBA is sort of giving us the authority to do that.
I'll make that motion to request that staff and township attorney prepare a draft resolution consistent with reflecting the consensus of the board tonight, as indicated by Mr. Martin in his comments, for our review at the next meeting for the release.
Anyone opposed? Hearing none, motion passes for that resolution approach.
Mr. Chair, I'd like a skipping matter on the only before you go on with the meeting.
Good.
I don't think this was mentioned at the last meeting, just for the late hour, straight adjourned, but there were were several references in the presentation at the last meeting to the depositions given by Briggs, DeVries, and Silico. I know that there are excerpts of the depositions in the printed materials, just as there are excerpts of the zoning ordinance in the printed materials, but I believe that full depositions were also made available, so I would ask that for purposes of complete record, that the Briggs, DeVries, and Silico depositions in their entirety be available for inclusion in the record should the record have to be assembled for any judicial proceedings.
Thanks for saying that was on that list. Well,
So do you need a motion to include those, or is that sufficient?
I would prefer a motion just to, yeah, and depending on your comfort level, it could be those and or any other depositions that have been excerpted. I'm trying to remember if those were the only three that were. But a motion just to make it clear that the ZBA is the one that's sort of perfecting the record and not me doing it unilaterally.
So I would make a motion that the full depositions of Briggs, DeVries, and Silico be included in the record. As excerpts of those depositions were provided and referenced numerous times throughout the presentation in this matter, as well as full depositions on full transcripts of other depositions if they were provided or received by the ZBA.
Support.
All in favor?
Aye.
Aye. Opposed? Motion passes. Conclusion of deposition request. Okay, I think. Yeah, that takes us to our next item on the agenda, item 5, public comment. And open it up to public comments. If you, I don't know if there's a sign-in sheet or if everybody has signed it in that would want to speak tonight, but they welcome you to the podium to do so at this time. If they're signed in now, I'll take them and read them off. Otherwise, we can put a blank one up here as well.
Mr. Chair, just a quick question. Do you want me to stick around for public comment, like historically in these situations? Because I'm charging by 6-minute increments, I've often been released. But if you want me to stick around, I will, but it's again going to be at your ZBA and Township expense.
I would prefer you did, but
Stay.
yes.
Yeah.
Okay.
There's a very short list.
Okay, sure.
We've got 3 people signed up. Now,
Sounds good.
is that okay?
That's perfectly fine.
I appreciate saying that. Okay, first person on the sign-in sheet that I see is Peter Snake. Snake. Sorry. If you don't mind, yeah, come on up.
I appreciate your time and I really appreciate everything that you're doing. It's a very difficult decision and a lot of things going on. I wish I had more to actually talk about some of these, but my one comment was in the last meeting, there was a lot of overriding comments on we don't have an STR problem, we have a landlord problem. My issue with that is that STR owners make money. Townships do make some money through taxes. Businesses do make some money through bumps, with more people coming into the area. But as a resident in a residential area, I have to be the policeman on this. I really don't want to do that. I don't want to call in people. I don't want to be looking at my neighbors. I just want to go home and just live my life. And that's really the crux of this. And I hope that you find that in zoning these are commercial use, in my opinion, and should not be in residential zones, residential neighborhoods. I'd like to keep those residential. So thank you so much for your time.
Jane Earl.
Mr. Chair, we do have a timer clock available. Would you like to use that?
Sure, I think that'd be fine. Set it in 3 minutes typically.
Oh, it would be the 3 minutes.
Okay.
No, my big concern was the last meeting where they kept talking about STRs as single family dwellings. It sounds as if that you've been questioning that as well, but I really object to it. I moved here about 27 years ago to a great little block with diverse people and ages and wonderful place. And then all of a sudden, one of the homes was sold as a STR. And there are 12 houses on the street with 2 to 4 people living in them. But this house, a realtor, when it was for sale, suggested in the realty in the online that this home could easily sleep 16 people. And that this was because there was a family room upstairs. There's bedrooms, but there's a family room. And so that could be used as dorm, which is pretty much what they've done. They have large groups of people there only for weekends. They have actually had a full-size bus come in with lacrosse teams. They've had smaller buses come in, and this is just to a small home built like in the 40s or something, and then remodeled to add this garage and upstairs level. So it really is, as I should have objected last week, because it is a mini motel. And I always wonder how you can have all those people in this room upstairs. If there was ever a fire or an exit, how would they ever get down this old just stairway? And I think it allows things that some of the motels like Marriott would not really allow you to do, bring a whole bunch of people in for bachelor parties, wedding parties, reunions, homecoming events. We even had bagpipers and of course the lacrosse team. So I guess I think I hope from what I heard, it's a lot of lingo stuff that I didn't understand, but I was hoping that you did not believe they were single family dwellings either. So I would just say, like the other gentleman, I moved to a comfortable residential neighborhood that's been changed by a flow of strangers going in and out of this place, and I would like my residents back.
Thank you, Jane. Tricia,
I actually submitted a letter prior to the last meeting, so I don't need to speak.
Okay, thanks for clarifying that. Bill Raycross.
My name is Bill Reichpost. My wife and I have owned our home at 1767 South Shore Drive since May of 2001. First of all, thank you for your work on the board and for hearing our input. As I hear recent comments, I do have a touch of empathy for the long-term cottage owners that have occasionally rented to family or close friends, but will no longer be able to do so. Enforcement of the ordinance will bring that to an end. But the reality is that when the use of internet-based rental sites, either directly by a business owner or through third-party property management companies came into vogue, neighborhoods were changed into something entirely different from their original character. The ability to rent to people on a weekly or even shorter basis via this avenue created an opportunity for business people which were not living on site to buy houses and turn them into businesses, renting to multiple people weekly, whether they were extended nuclear families or connected groups of friends, generating thousands of dollars in revenue. This, to me, is the business model that equates to running a motel, hotel, or resort, and those businesses should not be allowed in a residential zone in accordance with the ordinance and to preserve the community of our township. I respectfully ask that you do not grant exceptions or exemptions to the ordinance as is being requested. Thank you.
Good one.
Thank you. I just wanted to address one issue with respect to issue 1. And there was a discussion about whether or not the amendment in 2003 changed the definition, which it did. And I think it was perhaps suggested that pre-2003, it was the definition of motel was broad enough to include short-term rentals. And even if that's your decision, I think the application seeks more than that. The question 1 is, did the 1974 zoning ordinance, which as you'll see isn't defined, but up above is defined up until pre-2023, did it allow short-term rentals in residential districts? My point is if your decision is based on the definition of motel prior to 2003, you're going to leave a donut hole of 20 years of, well, was it a motel after the definition was changed, which was the entirety of our brief, by the way. So I would advocate for the ZBA, if nothing else, for the sake of the community and being sent back here on the basis of the 2003 definition of motel to address in its opinion whether or not under the 2003 definition whether or not short-term rentals are allowed, because that would be the relevant inquiry for a non-conforming use anyways. It would be what happened from 2003 to 2023. So I think not only that's what the application seeks that's the only definition we use, but I think, again, for the sake of answering the question whether non-conforming use could exist, that's got to be addressed in it as well. So thank you.
Thank you. For anyone else here tonight that would like to speak, you could approach. And if we sign it, we get out there.
Or I can sign afterwards. I won't waste your time. The one comment I noticed at the end of the last 4.5-hour session was Mika said their objective was not to change the character of the neighborhood. That was the objective of Park Township. And if that's been their objective, sort of surprises me, because I own a place. I've lived in McTowell Park since '57. And my place, it's a 2-family home. I live downstairs. I rent out the upstairs. It was always rented out before I bought it because it's a tourist area. It's a resort summer home. So when I first moved there, all the cottages were even rented out in the winter. We had a lively neighborhood. And since over the time, the hotel and motel Point West was sold and was just dormant for a while. And then when they wanted to build, the township said, oh yeah, you can have a permit and you can build all these big fancy homes in there instead of having a destination for people to come in and use a hotel or a motel or a restaurant. So it became a very private area. Then my neighbor said, well, I need a helicopter pad. So, oh yeah, that's okay. That doesn't change your neighborhood at all. So we had a helicopter pad put in and yeah. And, of course, there's the internet and all these other changes, but the boats have changed. We didn't used to have, the big boats that make all the noise, the Formula, whatever they are. But, everything changes. And I don't think I'm the noisemaker. I have 2 bedrooms that I rent out. I've been doing it for over 40 years. It's always happened. It's a summer resort. Oh yeah, and now as my cottages slowly became unoccupied by me and nobody's been in them, then for the last 3 years, they've been abandoned and now they just tore them down. So I used to live in a neighborhood with 8 cottages and now there's 3 cottages. Now they're going to maybe build a couple more, but we don't get any news about it. But I just, okay, I am not one. And I think I definitely belong in the thing that I did not change the character of our neighborhood. My neighborhood changed around me, but it wasn't due to STRs. Okay.
Did you sign it?
I'll get it.
Okay. Anyone else that would like to, that, comment period? Seeing no one up close public comment. And our next meeting is scheduled Monday, May 5th. Board to adjourn. All in favor?
Aye.
Any opposed? Carries. Meeting is adjourned. Thank you.
My neighbor.